All right, today we're diving into one of the most chaotic and transformative shifts in modern sports. Name, image, and likeness, or NIL. But we're not just looking at this as a legal change. For anyone studying sports law, and especially project management, this is a masterclass in how you try to manage a revolution when you have no plan whatsoever.
And really, that's the central question here. The story of NIL isn't some neat, planned-out project. Oh no. It's a century-old system just collapsing. And it forced everyone, from the NCAA down to university compliance directors, to try and build a brand new one while the ground was literally shaking beneath their feet. It is a project manager's absolute nightmare. Or maybe their ultimate challenge.
So to even begin to understand the new project, we have to look at the old one, and more importantly, how it completely fell apart. For decades, the NCAA's entire world was built on one core idea: amateurism. And as we're about to see, that idea was headed for a major reckoning.
Okay, first let's get our terms straight. NIL comes from a legal concept called the right of publicity. And it's a pretty simple idea at its core. It means that you, and only you, have the right to make money from your own identity. It stops someone from just slapping your face on a t-shirt or putting you in a video game without your permission and without paying you for it. Sounds simple in theory, right? Well, in the world of college sports, it turned out to be incredibly complicated.
If you look at this timeline, the legal idea behind NIL has been around since 1890. But the whole project of amateurism in college sports only really started to crack pretty recently. It arguably began with the O'Bannon antitrust case back in 2015. Then, in 2019, California basically threw a legislative bomb with its Fair Pay to Play Act. But the final blow, the event that just shattered the old model for good, that was the Supreme Court's 2021 decision in NCAA v. Alston.
Now here's a super important point that a lot of people miss. The Alston case wasn't actually about NIL. It was really focused on a much narrower question about whether the NCAA could limit non-cash, education-related benefits. The ruling itself was actually pretty limited, but it didn't stay that way, thanks to one justice's absolutely blistering opinion.
And here it is. This quote is the moment the entire project of amateurism lost all its legal and moral legitimacy. Justice Kavanaugh did not hold back, calling the NCAA's argument circular and unpersuasive. And that line, that their business model would be flatly illegal anywhere else? Whoa. That basically gave a giant green light to every future legal challenge. The old project plan was officially in the shredder.
So, with their old model dead and buried, the NCAA didn't have a new project plan ready to go. Of course not. What came next was just a chaotic, reactive scramble to make up rules on the fly, which, as you can imagine, quickly turned into a massive headache for anyone in compliance. Less than 2 weeks after the Alston decision, the NCAA drops its interim NIL policy. And you got to focus on that word interim. This was a band-aid, not a strategy. The policy basically just punted responsibility. It told schools, hey, just follow your state's laws. The problem? Some states had no law, and the ones that did often conflicted with each other. It created this messy regulatory patchwork, a project manager's absolute worst-case scenario.
And this is where it gets real, for anyone in a project management or legal role. Put yourself in the shoes of a compliance director. Your state law says an athlete can do X, but the new NCAA guidance hints that X is forbidden. Who do you listen to? Which set of rules is going to put your university and your athletes at greater risk? This was the confusing day-to-day reality on the ground.
And just to make things even more fun, the project requirements kept changing. I mean, the NCAA's guidance shifted dramatically in just 5 months. In May of 2022, they were all about clamping down on boosters. But by October, the focus shifted to what universities could do, like providing financial literacy or even helping collectives, those booster-funded NIL groups, with their fundraising. The goalposts were just constantly moving.
Then, in June 2023, the NCAA tried to claw back some control. They sent out a memo saying that, hey, our rules trump state law when the two don't agree. It was a bold move to try and regain authority, but for the schools, it just piled on more risk. Now, if you followed your own state's law, you could be in direct violation of NCAA rules. It just added another layer of complexity to a project that was already feeling impossible. Okay, so that chaotic scramble couldn't last forever. A landmark legal settlement finally forced everyone's hand, creating a brand new project. And this one is centered on an idea that used to be completely unthinkable: schools directly paying athletes.
The real game changer here is the House v. NCAA settlement.
This isn't just another piece of guidance. It's a fundamental restructuring of the entire system. For the very first time, it allows divisionized schools to opt into a model where they can directly pay their athletes. This is the official start of what you could call Project NIL 2.0.
So the project requirements for this new era are a lot clearer, but they're also way more demanding. Now schools can directly pay athletes who can negotiate deals before they even set foot on campus. But with that new freedom comes a lot more regulation and a renewed focus on academic progress as a key gatekeeper for eligibility.
So, from a project management standpoint, this all translates into real, concrete deliverables. First, disclosure. You have to track and report every single deal. Second, oversight. You have to set up a process for potential third-party contract reviews. And third, eligibility. You've got to build a system to constantly monitor academic progress. These aren't vague guidelines anymore. They are specific, actionable tasks.
And if you want proof of how detailed this new project is, look no further than this number, $600. This is the new magic number. Under the new system, student-athletes have to report any NIL deal that's valued at more than $600. It's such a simple rule, but it creates a massive new data tracking and reporting job for every single compliance department.
So here's the real takeaway. We've moved from pure chaos to structured complexity. The Wild West era of NIL is pretty much over. It's being replaced by a formal, highly regulated system. And for the project managers and lawyers in charge of all this, the job is not getting easier, it's just becoming more defined.
And that really brings us to the final question. The revolution might be settling down, but the project of managing its aftermath has just begun. With every new rule, every disclosure form, every contract, comes a whole new world of risk. The challenge now isn't just surviving the chaos, it's mastering the complexity. So, are you ready for it?